Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officers, officials, listeners and learners. I welcome all respected doctors and directors, honorable ministers and managers, honorable advocates, supervisors, administrators and advisors, the most honorable present person Modi, I heartily cordially welcome. It is really nice time, nice place, nice section today that we are explaining, defining, expressing our Indian Constitution in the form of unity and diversity. Privileged class, divines and juvenile delinquency. Let us discuss the unconstitutionality of third degree method. Police is the security guard of society. His main work is maintaining peace and order in society, provide security to society, protecting society from criminal elements, investigation of crimes and detection of criminals, protecting public property, the public has full faith in the police and expects them to protect the police's, the public's property and provide protection from criminals. But today the situation is different. The police are openly abusing their powers while being distracted from their official duties. This is the reason that today the public trust in the police is starting to waver. There is fear of police in public. It would not be wrong to say that instead of providing security to the public, today it is torturing the public life. Those arrested are subjected to barbaric conduct. They are beaten up, hit by the butt of a gun or rifle, hit with a leather belt, fired with a burning cigarette. All day long it is kept in the sun and the rooster is made. Electric current is applied, stipend to be done, kept hungry. Female prisoners and accused are exploited. Innocent people are kept in police stations and checkpoints, enforced to give evidence, torture for acceptance of crime. It is third degree method. Once Justice Govardhan Lal Ojha of Madhya Pradesh High Court said that today the police wants the accused Yankan to confess his crime, and for this he uses third degree method. In the matter of Mrs. Salvi versus State of Karnataka, year 2010 SC 1974, it was held by the Supreme Court that right of police to investigate offence and examine any person do not and cannot override constitutional protections. In the case of Nandini Satpathy versus P.L. Dani 1978, 2 SSCC 424, there were allegations of corruption against former Odisha Chief Minister Nandini Satpathy was brought to the police station to investigate those allegations and was forced to answer some written question. Satpathy refused to reply, citing Article 23 of the Constitution. It was prosecuted against him under Section 176 of the Indian Penal Code 1860. It was determined by the Supreme Court that Nandini could not be compelled to give evidence against herself. This is an example of third degree method. The Delhi Judicial Service Association versus State of Gujarat KAR 199 SC 2177 has a much talk about issue. In this, the police officers of Nadiad city of Gujarat were handcuffed in the hands of the chief judicial magistrate there and were treated with indecent behavior. It is third degree method. Violence and torture have become a common practice in police custody. Violence is used openly towards persons who are kept in custody, which is called custodial violence. Sometimes death also takes place in custody. In the matter of Munshi Singh Gautam versus State of Madhya Pradesh, PIR 2005 SC 402, it was held by the Supreme Court that the suggestion given in the 130th report of the Law Commission of India for the prevention of custodial violence should be implemented. In the case of D.K. Basu versus State of West Bengal AIR 1997, SC 610, inhuman treatment and torture of a person arrested by the police was condemned by the Supreme Court, and it was described as an infringement of Article 21 of the Constitution. The Supreme Court said that the police have no right to use cruel, inhuman, and third degree method during investigation and investigation. A 22-year-old youth arrested in Nilavanti, Bihar versus State of Odisha, 1999 SSC 746 case, died due to torture, and his body was found lying near the railway station with handcuffs. The Supreme Court, considering it a custodial death, entitled the heirs of the deceased to be compensated from the state. In Prem Shankar versus Delhi Administration AIR 1980 SC 898 case, Supreme Court did not justify keeping prisoner in handcuffs for 24 hours. Similarly, in the case of Ishar Singh versus State of Rajasthan AIR 998 SC 625, the Supreme Court considered the detention of an inmate with handcuffs for 8 to 11 months on trivial grounds. In the matters of Joginder Kumar versus State AIR 1994, SC 1886 and DK Basu versus State of West Bengal, AIR 1997 SC 610, it was held by the Supreme Court that the police should remove the word torture from its dictionary because it is a wound in the mind, because it is a wound on the mind that can be touched but cannot be filled. During the interrogation by the police in the case of Yusuf Ali versus State of Maharashtra, AIR 1968 SC 115, one person was beaten, starved, and tortured. It is considered unjust. In the matter of Niranjan Singh versus Prabhakar Rajaram AIR 1980 SC 785, it was held by the Supreme Court that due to custody violence and torture, the police had become an institution to create fear and terror in the public instead of protecting it. Thus, the overall conclusion is that the third degree method used by the police is completely unconstitutional and violates Article 21 of the Constitution. This argument given in support of third degree method is not valid in the rule of democracy and law. That third degree method is necessary to be used to deal with habitual and notorious criminals. It is difficult to reach such criminals without the use of third degree method. Let's explain the rape and related forms of gender based aggression committed by the police and paramilitary forces are worst form of brutal crimes. It is alleged that brutal crimes are committed by the police and paramilitary forces related to rape and gender-based offences. Do you agree with the above statement? Let's define it with the supportive arguments. Let's give a critical analysis of the problems of rape and other atrocities against women in custody by police and paramilitary forces. How far the apex judicial body of India has taken cognizance of it. They have discussed some important decisions with regard to prevention of such offences. Police is the security guard of the society. He is responsible for the safety and security of the society. The public trust and honors the police. It can be said that the police is the custodian of society. The police investigate crimes, arrest criminals, and write statements of witnesses. They can also have women. Women can be called to police station for questioning. Criminal women can be arrested and kept in custody. In such cases, the responsibility of the police increases even more. They bear the responsibility of protecting those women. Police have to be alert for the safety of women. In these circumstances, the police become the guardian of women. But if the police cheat with them, misbehave with them, disrespect their shame, and come down to rape, then it is unfortunate. Nowadays, such incidents have started happening frequently. Police and paramilitary forces do misbehave, molest, disgrace, rape. Women are molested and raped by police in lockup. It is often heard that women passengers are molested and raped by the police and paramilitary forces on the running trains. Women are raped during patrolling at night. This is a terrible situation. Women are expected to be treated with courtesy and decency. What's the meaning of arrest? Special prosecution are required to be taken at the time of arrest of women in the matter of state of Maharashtra versus Christian Community Welfare Council of India AIR 2004 SC7. It was held by the Supreme Court that a woman arrest should be made in the presence of a female constable. If a female constable is not present or not available, the reasons thereof should be shown. It is meant that at the same time of arrest of the woman, it is necessary to show courtesy and decency. What is search? A woman's search is also required to be taken with courtesy and decency. To the extent possible, a woman's search should be conducted by another woman, but the police are also rude in many searches. In the matter of Kamlabai Jetmal versus State of Maharashtra year 1962, SC 1189, it was held that it is considered rude to remove money by putting a hand in her blouse during all the searches. Similarly, in the matter of Motilal versus State 24 LT 445, it was held that removing a purse from a woman's petticoat during search is considered rude. These are cases of sexual harassment of women by the police. This can be called a disgusting act of the police. Disgrace and rape. Disgrace and rape of women in custody is a highly disgusting and cruel act. Rape is a crime against humanity. State of Rajasthan versus Om Prakash Ayar 2002 SC 2235. Rape is a serious social crime. State of Punjab versus Rakesh Kumar AIR 2009 SC 391. Rape is a violation of women human rights. State of Punjab versus Ramdev Singh AIR 2004 SC 1290. Rape imposes a permanent stigma on the woman. She starts to feel disrespected. Rajendra Dutt, Jericho versus State of Goa, AIR 2008 SC 572. The life of a woman suffering from rape becomes hellish. Life becomes bleak. She starts to feel guilty to herself. She feels tarnished. His physical wounds heal, but mental wounds do not heal. Puspanjali Shahu versus State of Odisha, AIR 2013 SC 1119. In this way, rape is a disgusting and serious act and crime. If the same work is done by police or paramilitary forces, if the same work is done by police or paramilitary forces, then it becomes cruel. Penal provisions. Section 375, 376, 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB, and 376E of the Indian Penal Code provides for rape. What is rape? The definition of rape is given under Section 375 of Indian Penal Code 1860. According to this 375 rape, a man is said to commit rape if he penetrates his penis to any extent into the vagina, mouth, urethra, or anus of a woman, or makes her to do so with him or any other person, or inserts to any extent any object or a part of the body not being the penis into the vagina, the urethra, or anus of a woman, or makes her to do so with him or any other person, or manipulates any part of the body of a woman so far, or manipulates any part of the body of a woman so as to cause penetration into the vagina, urethra, anus, or any part or body of such woman, or makes her to do so with him or any other person, or applies his mouth to the vagina, anus, urethra of a woman, or makes her to do so with him or any other person, under the circumstances falling under any of the following seven descriptions. First, against her will. Second, without her consent. Third, with her consent when her consent has been obtained by putting her or any person in whom she is interested in fear of death or of hurt. Fourth, with her consent when the man knows that he is not her husband and that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. Fifth is with her consent, when, at the time of giving such consent, by reason of unsoundness of mind or intoxication of the administration by him personally or through another of any stupefying or unwholesome substance, she is unable to understand the nature and consequences of that to which she gives consent. Sixth is with or without her consent when she is under 18 years of age. Seventh is when she is unable to communicate consent. Explanation number one. For the purposes of this section, vagina shall also include labia majora. Explanation number two, consent means an unequivocal voluntary agreement when the woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not by the reason only of that fact be regarded as consenting to the sexual activity. Exception 1. Exception number 1. A medical procedure or intervention shall not constitute rape. Exception number 2. Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape, substituted by Penal Laws Amendment Act 2013 punishment for rape. Section 376(2) provides punishment for rape by police officers and policemen and members of paramilitary forces. According to this, whoever being a police officer commits rape within the limits of the police station to which he is appointed or in the premises of any station house, whether or not situated in the police station to which he is appointed or on a woman in the custody or in the custody of a police officer subordinate to him. He shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to life imprisonment, which shall mean imprisonment for the remaining natural life of that person, punishable and also punishable with fine, while committing rape in that area, being a member of the armed forces deployed in any area by the central or state government, he will also be punished with the above penalty. Whoever with any woman when he is under 16 years of age will rape shall be punished with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to life imprisonment, which shall mean imprisonment for the remaining natural life of that person, punishable and also punishable with fine. But such penalty shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any penalty imposed under this section shall be paid to the victim. 376A. Punishment for causing death or resulting in persistent vegetative state of victim. Whoever commits an offense punishable under section 1 or subsection 2 of section 376 and in the course of such commission inflicts an injury which causes the death of the woman or causes the woman to be in a persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life or with death. 376 AB. Punishment for raping a woman under the age of 12. Whoever with any woman when he is under 16 years of age will rape shall be punished with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to life imprisonment, which shall mean imprisonment for the remaining natural life of that person, punishable and also punishable with fine. But such penalty shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any penalty imposed under this section shall be paid to the victim. 376b. Sexual intercourse by husband upon his wife during separation. Whoever had sexual intercourse with his own wife, who is living separately, whether under a degree of separation or otherwise, without her consent, shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years, and shall also be liable to fine. In its explanation, in this section, sexual intercourse shall mean any of the acts mentioned in clauses A to D of section 375. 376c. Sexual intercourse by person in authority who ever been in a position of authority or in a six fiduciary relationship or a public servant or superintendent or manager of the jail, remand home or other place of custody established by or under any law for the time being in force or women or children's institution or on the management of a hospital or being on the staff of a hospital, abused such position or fiduciary relationship to induce or seduce any woman either in his custody or under his charge or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to the offense of rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 6 years, but which may extend to 10 years and shall also be liable to fine. Explanation number one says, in this section, sexual intercourse shall mean any of the acts mentioned in clauses A to D of section 375. Action number 2 says, for the purpose of this section, explanation 1 to section 375 shall also be applicable. Action number 3 says, superintendent in relation to a jail, remand home or other place of custody, or a women or children institution include the person holding any other office in such jail, remand home, place or institution by virtue of which such person can exercise any authority or control over its inmates. Action number 4 says, the expression hospital and women's or children institution shall respectively have the same meaning as in explanation to subsection 2 of section 376. 376d, gang rape, where a woman is raped by one or more person constituting a group or acting in furtherance of a common intention. Each of those persons shall be deemed to have committed the offense of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life and with fine. provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, providing further that any fine imposed under this section shall be paid to the victim. 376 DA punishment for gang rape on women under 16 years of age, where a woman under 16 years of age is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offense of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any fine imposed under this section shall be paid to the victim. 376 DB punishment for gang rape on women under 12 years of age, where a woman under 12 years of age is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offense of rape and shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and with fine or with death, provided that such fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, provided further that any fine imposed under this section shall be paid to the victim. 376E punishment for repeat offenders. Whoever has been previously convicted of an offense punishable under section 376 or section 376A or section 376AB or section 376D or section 376DA or section 376DB and is subsequently convicted of an offense punishable under any of the said sections shall be punished with imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life or with death. Section 376AB, 376DA, 376DD, and 376 are substituted by Penal Laws Amendment Act 2018 in the matter of Ram Kumar, versus State of Himachal Pradesh, AIR 1995, SC 1965. It was held that Khemaraj's wife was aggrieved of raping by two policemen named Nan Singh and Ram Kumar. These two policemen seduced the victim to the police station and raped her there. They were convicted of rape. In the matter of state of Maharashtra versus Chandra Prakash Kevalchand Jain, area 1990 SC 650A, it was held that he is not eligible for sympathy for a young girl being raped by a uniformed police officer. Such a person should be punished with severe punishment. In the matter of in the matter of Puspanjali Sahu versus State of Odisha AIR 2013 SC 1119, it was held that the lady warden of the hostel was raped by the watchman. While punishing the watchman with harsh punishment, the Supreme Court had said that the life of a woman suffering from rape becomes hellish. Life becomes bleak. She starts to feel guilty to herself. She feels tarnished. His physical wounds heal, but mental wounds do not heal. Overall, it can be said that raping a woman by a police officer or policeman is a serious and a hate crime. Strict punishment is the only solution in such cases. That's right, and not on encounter killing, terrorism, and nationalism. Terrorism and nationalism is a burning problem in front of the whole world. Today, the whole world is burning in the fire of terrorism and nationalism. Terrorists and nationalities, terrorists and nationalites are giving death to innumerable innocent people on the day. Terrorists are wreaking havoc on the metropolis and the nation's border. The Mumbai bomb blast case is a direct example of the barbarity of terrorism. Many innocent people are being killed today through firing, bomb blast, firing, etc. It is very difficult to catch and arrest such terrorists and Naxalites. Till date, hardly any terrorist and Naxalite could be arrested. In exceptional cases, terrorists are caught and prosecuted against them. Special courts have also been formed for such people. Despite all this, control over terrorists and Naxalites has not been established. Even today, they are free to engage in violent activity. After mass violence, organizations of such terrorists take responsibility for the incident. Such terrorists and Naxalites also attack the police on the occasion, killing many innocent police officers and policemen. Many armed policemen posted on the border of the country are falling victim to death on the day of the terrorist attack. One way to prevent such incidents is encounter killing. We read the news of such a murder in the newspapers daily. When terrorists, Naxalites, or criminal elements resort to violence, then our policemen also resort to violence in defense and make them victims of death. It is called as encounter killing. Although killing in an encounter is not legally valid, but according to the criminal procedure law, the incident is not usually investigated after death. Criminal cases end on the death of the accused. Even if some cases are going on, they go on so long that their important ends and the wounds of the incident heal. The case of Shahabuddin encounter is a vivid example of this. Many times, Commission of Inquiry is also set up to investigate murder cases in encounter, but they do not yield any effective results. In this series, some underworld criminals also come who are called underground. Encounter killing is the only way to deal with it. The truth is that today encounter killing is considered a circumstantial way to deal with habitual and notorious criminals, terrorists and Naxalites. Encounters are now being considered as weapons of defense. By the way, the incidents of encounter keep happening on the coming days. People of both the sides are usually killed in encounter killing, and both sides resort to personal defense and defense. Encounter killing has become such an act which is situated between legal and illegal. If it is condemned legality, if it is condemned legally, it is supported as a defense. Generally, the government also supports encounter killing because its direct responsibility falls on the state. Ultimately, encounter killing can be called a necessary evil. Let's critically examine let's critically examine the suggestion made by National Police Commission. Police is an important part of society. He is the security guard of the society. It is his responsibility to protect the property. She protects against criminal and antisocial elements. In the matter of Manorlal versus Vinesh Anand AIR 2001 SC 1820, it was held that criminals are required to be prosecuted for the safety of society. This responsibility rests with the police. In this situation, it is necessary to strengthen the police. Keeping all these things in mind, the National Police Commission was constituted by the central government on November 15, 1977, under the chairmanship of former Governor Dharamveer, to improve the working efficiency and working style of the police. KF Rustamji, NS Saxena, MS Gaur, and NK Reddy were made members in this commission. CV Narasimha Rao, CV Narasimhan was appointed as member secretary of it. A total of 8 reports were presented by this commission in its 3.5 year tenure. In its scope, in the present environment, the role of police in maintaining peace and order in the country and in the prevention of crimes is to review the duties, power, responsibilities, and style of functioning, to evaluate the existing police system and suggest suggestion for its improvement, suggesting for redressal of delays in current investigation and prosecution system so that cases can be expedited and disposed of, to consider and suggest possibilities of uniform police statistics across the country, to consider possibilities of improving the sources and methods of current crime statistics, to inspect the police system of non-rural areas, to consider and suggest the use of tools in line with modern science and technology in police work, to consider the special responsibility of the police towards the weaker section of the society and suggest measures to take prompt action on their complaint, suggesting appropriate training and development programs for policemen, to consider the possibilities of mutual cooperation between the police and the public and to make suggestions accordingly. Along with this, the Commission has also been asked to suggest the following: police abuse of powers, protection of police from political pressure, resolve the problems of the police and consider them sympathetically, and proper welfare schemes for policemen, etc. All the above mentioned points were seriously studied, thought, pondered, and brainstormed by the Commission, and reports were presented to the government from time to time. In its various reports, the Commission made several important suggestions regarding improvement in police functioning. Suggestions The main suggestions made by the Commission in its reports. One is the present Police Act 1861 should be repealed and a new Police Act should be made in its place. Two is Central Police Commission at the center and State Security Commission should be established in the states. Three and all India Police Institute should be established. For is the following tasks should be entrusted to the State Security Commission: preparation of instructions and policy for the prevention work of police, annual review of the state's police functions and report before the state legislature, to consider the reports of superintendent of police and higher officials and redress their grievances, consideration of reports relating to promotion of high police officers. The police should not abuse their powers of arrest and confine it to Section 41 of Criminal Procedure Code 1973. Interference in police action should be stopped so that police morals does not fall. Double control over the police should be reduced. One is the control of politicians and the other is control of high officials. If politicians pressure the police for wrongdoing, then high officials expect flattery from them. Due to which policemen are unable to act with independence and falseness. Third degree method. Third degree method should not be used by the police and no one should be tortured. During investigation into cognizable offences, the accused should be arrested only under the following condition: in cases of serious nature such as murder, robbery, rape, etc. Two is where the criminal is expected to flee. Three is when the criminal is habitual and notorious. Four is criminals of violent nature. Thus, many important suggestions were made by the National Police Commission. These suggestions have also been implemented. The new Police Act has also been passed. Police violence and torture have also decreased. The police is being endowed with modern scientific instruments. Arrangements have been made on Arrangements have been made to train them from time to time. Police Training Institute established. In the matter of Rakesh Kumar Pal versus State of Odisha AIR 2017 SC 3948, it was held by the Supreme Court that scientific investigation is the need of hour. What do you mean by white collar crimes? Critically evaluate the social economic offenses committed in India. Let's define white collar crimes. State Let's state the main reasons of the increase of such offences in India. White collar crime is a menace to the social setup. Let's comment on it. White collar crimes are committed for greed and not for need. Let's explain. State the concept of white collar crime, an Indian approach to socio-economic offences. Faith means policy, honesty, religion, duty, etc. are the main characteristics of human beings. A person who loses these features does not have a reputation in society and family. Society sees such a person with inferiority. Such people are sometimes considered criminal in society, but sometimes the opposite is also seen. Such individuals become more prestigious in society than they are. There is a difference between their words and action. These people are different from inside and something different from outside. Their criminal mind looks like a glow of milk outside. They wreak havoc on the society, but the society still respects them. All these things happen only due to wealth. These people earn huge amount from black marketing, smuggling, adulteration, bribery, etc. This is white collar crime, and white collar crime talking taking illegal advantage of their position and reputation in the society. They do illegal work. The weight of his reputation falls on these illegal acts and crimes. Such people are not punished even in society. These people keep the law in their grasp. Such people are called white collar criminals. In its definition, the naming of white-collar crime was first attributed to criminologist Sutherland in the year 1914. He has given it in the definition that the crime committed by a person of reputed and high honor and position in the course of his business is white-collar crime. He later made some improvements to his definition and gave this revised definition: violation of criminal law by people of high social and economic class in activities related to their trade, business, and profession is white collar crime. P. Goswami said that violation of law done by high ranking person under the guise of their reputation is a crime. In this way, it can be said that trespassing in the form of trafficking, black marketing, adulteration, and bribery, etc., in the guise of dignity and honor by persons called reputed in society, is a white collar crime. Dr. Basanti Lal Babel says, features of white collar crimes. What are the features of the white collar crimes? One is such crimes are committed by a person of high status in society, to which these are done during activities related to their trade or profession. Says its purpose is to gain unfair advantage or to earn huge amount for a such action violate any commercial or other law. While such crimes are committed explicitly and are secretly done behind the scene. Six says such crimes not only adversely affect the interest of the general public but also betray them. For example, the trader is expected to give the goods in pure means without adulteration. But if he gives adulterated goods, if it not only adversely affects the health but also betrays the customer. Such criminals are out of the grip of governance and law. What are the types of white collar crimes? Classifying white collar crimes is difficult. Classifying white collar crimes is difficult as scientific experiments are increasing. The number and nature of these crimes is also increasing along with the ray of hope of entering the 21st century. The rate of increase in these crimes are also emerging. Human's criminal mind is constantly engaged in the invention of new crimes today. The crimes which we can call or believe as white collar crimes are mainly trafficking, black marketing, adulteration, bribery, illegal gratification, embezzlement, trustworthiness, fraud, forgery, cheating, theft, tax fraud. But love affair, rape, murder, or suicide in love affair cannot be called white collar, as they are neither done in the sequence of trade business nor do they have objective meaning. Reasons of white collar crimes. White collar crimes increasing white collar crime is a burning problem of today. The more the diagnosis is being made, the more the problem increases. If this is said when if this is said, then there will be no exaggeration that today it is an incurable problem. The reason for this is not understood. The reason for this is also clear because it is not one but many. Criminologists have failed to reach the following reasons after deep thinking: greed and selfish tendencies. The tendency of greed and selfishness in human is the main reason in the era of increase in white collar crimes. In this materialistic era today, everyone wants to get ahead in the economic race. He is engaged in earning money in any way. He does not pay any attention to the policy. A person cannot become a millionaire overnight with hard work, honesty, etc. Therefore, in the dream of becoming a millionaire overnight, he resorts to meaningless fraud, deceit, etc. He makes smuggling, black marketing, adult, adulteration, etc. the medium of his earning. Luxury, increasing luxury, and the influence of Western culture have also inspired humans to commit white crimes. Today's humans wants to live a life of comfort. He does not accept anything from himself with simplicity. He tries to meet the expenditure on luxury in any way. In such a situation, he does not worry about theft, forgery, fraud, adulteration, embezzlement, etc. Hundreds of crimes have also been seen behind lover and girlfriend. Policy and law are kept on hold. The wife of a collector can bring any sari she wants from that shop. When he is exposed by the journalist is harassed illegally by the collector only for the happiness of his life. This is also a white collar crime. Capitalist economy. Its third reason is capitalist economy. In the capitalist economy, the capitalists are given an important place. The poor person is seen as inferior. It has no place in society. That is why every person wants to be a capitalist in any way. Even if he does not commit 100 crimes, then in a capitalist economy, industry and trade become puppets in the hands of the capitalist. They exploit society in every way. The common man does not have the courage to oppose them. The government also cannot take action against such a person. Lack of public awareness, ignorance of the law, and lack of awareness is also a major reason for the increase in white collar crimes. Today, a normal person does not know what is a crime and what is not a crime. If a person is not aware of this, then the process of taking action against him is not known. Hence, there is no action against such crimes. For example, under Section 12 of the Prevention of Food Adulteration Act 1954, the buyer can also analyze adulterated food item, but the public is not aware of this. He believes this and knows that only such analysis can be done by the government. Government and common man apathy. Many times the government and the public remain indifferent to them. Despite knowing about the white robes, the public is indifferent. The public is indifferent because it does not have the capability to take on the white collar criminals. It knows that the government will suppress the case and unprovoked enmity will arise. If a person also has the power to fight against white collar criminals, then due to lack of funds, he is unable to take further steps. The government remains silent on such crimes for its many reasons and interests. Corruption, wars, election donation, etc. are prominent in this. Inadequate panel system. It is said that without fear, it is not possible to prevent crimes. Fear arises due to the penal system of imprisonment, while most white collar crimes lack such a penal system. Many cases related to white collar crimes are usually heard by administrative tribunals who have no right to pass the sentence of imprisonment. They can only impose penalty on which white collar criminals have no fear. This is why there is no fear of law in the minds of white collar criminals and they continue to commit such crimes fearlessly. Then here is another thing that even if there is a strict penal system, it is only for poor people, great white collar criminals by justice. Till date, no big white collar criminal has been seen being shut down like the poor in the box of law. This is why Johnny Bentham had to say, justice is sold in this country and that too at high prices. He referred to the judges as a judges and company. Why judges, in my opinion, even lawyers take context to save white collar criminals with high fees. It is a bitter fact that the Advocate Institute had emerged to save innocent people, while they consider it not only their duty to save the guilty, but also consider it their skill. This is unfortunate. Complexity of law. The complexity of the law is also a thorn in the prevention of white collar crimes. The law is so complex, ambiguous, and unclear that prima facie the case cannot be settled for years. Due to this, in the minds of the complainants and distressed people, there is disrespect towards the justice system, and criminals also fearlessly wander. Simultaneously, criminals break the law and escape. The benefit of doubt benefits criminals. Creating doubt is a game of his left hand. There are some white collar crimes for which there is no legal system. For example, no law existed before the Human Organ Transplant Act of 1994 regarding transplantation of human organ. Even in the year 1994, this act was made. It was not implemented in all the states. This led to the trade of human organs, the effect of white collar crimes. White collar crimes that termite that is following out the society inside itself. This is one such fish which is polluting the entire pond. Its effect is wide. This is leading to economic imbalance. The gap between rich and poor is increasing day by day. The rich are becoming richer and the poor get poorer. In other words, it can be said that this is an obstacle in the path of socialism. This has led to a deterioration of human values and a decline in morality. Human being today is not able to live honestly even though he wants only the rich class in the society. Poor people forget their policy and honesty. Seeing the luxury of white collar criminals, they either join the white collar gang or start committing such crimes independently. White collar criminals ask only one question to honest people: what is kept in honesty? Honesty is unhappy and dishonest happy. This criteria of happiness and sorrow shakes the faith of human beings. The government also has to bear the loss of lakhs of rupees every year due to white collar crimes. White collar criminals harm the government in the following ways: tax evasion by illegally producing alcohol, by smuggling, adulterated by other means. If white robbed criminals are labeled as traitors, it will not be unfair. They not only deteriorate themselves but also spoil the future generation of the country. Dominance, white collar criminal. Counting white collar criminals towards white collar crimes is also not an easy task. Due to selfishness and luxury, honest people also tend towards this. Sometimes even such people become white collar criminals, which cannot be imagined even in dreams. Teachers, judges, and doctors, etc., are some of the businessmen who have their own separate place in the society. Their corrupt practices also cannot be thought of. But when they start behaving corruptly, then the number of white collar criminals increases. This is the reason why the number of white collar criminals cannot be determined today. Still today, the main white criminals in society is the following. One is the merchant. The most white collar criminal in society is the business class people. The tendency for the most selfishness is found in them. These people are also fallen from moral point of view. Tax evasion, fraud, smuggling, black marketing, adulteration, etc. all do this class. Switzerland had started 75% of this in society. Illegal manufacture and trade of opium, hemp, cannabis, hashish, heroin, liquor, etc. also do this class. Government officer, government officials are also second to none in the race for white collar crimes. It has become common practice to do illegal work by taking huge bribes. Not only this, they also make liquor and girl a medium. Today, police department or judicial, mechanical department or administrative, all are victims of this disease. Political leaders, if this is said, then there will be no exaggeration. There will be no exaggeration that the politician is in the forefront of the race of white collar crimes, giving contacts with huge amount, issuing licenses, etc. is their left hand game. Frauds in lakhs in government purchase and sale are as if it's right. The, before the Bofors scandal, The Fairfax scandal is a recent example of this. Doctors, life-giving doctors, have also jumped into this field today. The manufacture and use of counterfeit medicines, sale of medicines to hospitals, demand of use fees, preparation of false medical reports, illegal abortion, etc., have become a part of their business. The situation has come so far that even a poor person is unable to diagnose his disease. It has also been seen that the doctors demand high fees while the patient is in the surgery room. The incident of kidney transplant in a private nursing home in Jaipur, Rajasthan is a recent example of this. It happened that some poor people of the society needed money for their family needs when he did not expect to receive money from anyone. He sold his kidneys. These kidneys were transplanted to some for rich people. What is the trade of human organs of this type if not a white collar crime? Surprisingly, the Human Organ Transplant Act 1994 was passed by the parliament but it was not implemented in Rajasthan till then. Lawyer. This class which pretends to bring justice to the suffering, frustrated and distressed of society is also coming forward in the line of white collar crimes, charging huge fees from poor people, distorting facts, hiding the right facts, preparing false evidence, meeting with both sides, bribing officer class etc. is white collar work. This class of writers' experience today has become a hindrance rather than a seeker in the path of justice. Teacher, the education world, considered the most sacred of the society, has also fallen victim to this disease. There was a time when education and teachers were considered the highest place in the society. But today the situation has changed. Today the teacher is viewed with inferiority. He is ridiculed in society. The reason is clear. Today the teacher has been distracted from her path, not teaching in school by heart, taking the students at home with tuition and passing the exam has become the right of the teachers. This is This is why Eklavya of today wants his guru's thumb. Now he is not ready to give his thumb to Dronacharya. The author remembers the story of a professor of his friend. The professor was teaching writing of Jai Shankar Prasad in class. He taught all the success in 2 days. Then a student said that, Sir, Jai Shankar took years to write Kamyani and in you finished it in 2 days. The professor replied that in the salary of 500 rupees, Kamyani will be studied in this way. Stein, it is extremely regrettable and shameful that the religious place, the holiest establishment of the society, had also joined the link of white collar crimes. Today, religious places are being made the base of crime. There are robberies, murders, rapes, etc. The religious leaders are openly looting the public on the pretext of rituals under the guise of dharma. Religion and spirituality are being created. Thus, white collar crime pervades society like a canker. The security of the society is in this way that these crimes should be completely destroyed. Dear friends, tomorrow we will discuss What is bias? What are its various kinds? Bias is a form of corrupt practice. What do you understand by lecture method of teaching? Teaching has many ways, like teaching by lecture method, teaching by cash method, teaching by problem method, etc. Among all these, lecture method is most famous and prevailing according to the reports of Peterborough University. Often, the cornerstone of university teaching is often the cornerstone of university teaching. A lecture can be an effective method of communicating theories, ideas, and facts to students. For example, in universities, lecture method can be seen effective by following ways. One is theories, two is ideas, three is facts to inform the students. In lecture method, oral lectures are given by law experts, principals, professors. By lecture, students of law get aware about the theories, ideas on method of research and facts. Teachers or professor fulfills the curiosity of law students by their good skill of teaching. Students are awarded by providing them knowledge regarding new techniques. As much the lecture shall be effective, that must effect and satisfaction shall be on students. The satisfaction of students depend upon the wise lecture. It is said in the report of Pittsburgh University that the basic purpose of lecturing is the dissemination of information. As an expert in your field, you identify information by the learner and transmit this knowledge in the lecture. The lecture method is recommended for high consensus disciples disciplines, those in which there is agreement on the fundamental principles and procedures such as math and the natural sciences. Such as the main object of lecture method is spread over the law with related information, facts, ideas. Plan of lecture. How should be the plan of lecture or how should be it prepared? It's an important question. It is the thought of researchers and law experts that procedure of teaching should be included in lecture. Lecture should be such which is easily understood by student. Such lecture is considered as effective. Effective lecture should have three elements. One is introduction, two is main part, three is conclusion. In its introduction, the first part of lecture is called introduction. It is generally of 3 to 5 minutes in this short time. Students are explained the object of the lecture, which is about to deliver to them, along with the points which are included in lecture. The object of introduction is to make students aware about the subject matter of lecture. The presentation of introduction must be such that it can attract the interest of students. If students wouldn't be interested in lecture, then that would become useless. The presentation of introduction is expected by following: establish interaction with students. For example, presentation must be in such way that it could develop interest in students regarding lecture. Make students active and encourage them to relate with lecture. Present such kind of problems in front of students that they become curious to solve it. Clarify the object of lecture and describe how to use it. Declaration of subject as title. Discuss about the subject and clear that how to develop it. Its main part, we call it body of the lecture. It includes the content of lecture systematically. Following matters are included in the main part of lecture. One is fact, two is presumption, three is theory, four is simplification. In the middle of lecture, it can be said to students that it should be specially taken in account. Two is please write down them. Three is theory and four is I would like to ask from you that. Five is you must remember that. In its conclusion also has an important role in lecture, but generally it is ignored at the end of lecture. Should must be told about the conclusion. Conclusion basically involves repeat the subject in brief and remind the main points of lecture. Establish link between provision. Establish link between previous and past subjects. Points to be considered for a good lecture. Following points should keep in mind for a good and worthful lecture. One is keep distance between speaker and listener. Two is take care of physical activity with face expression, four is expression, five is voice, six is pronunciation, seven is limit of speech and expression, eight is types, and nine is use of short lines. Let's discuss about the advantage and disadvantage of lecture tomorrow. Is the lecture method is appropriate to teach young legal students, or should it be constitute, or do you feel that it has become demerits, so new methods should be adopted? Criminology and criminal justice administration. Let's state the classification of crimes under the Indian Penal Code. What are the various kinds of crimes? Let's explain it. Crime is a dynamic concept which changes according to country, time, and circumstances. The passage of their origin and development is very long. During this period, not only the number of crime has increased, but new crime have also emerged. The stage of crime has reached from theft to cyber offenses. As far as the classification of crimes is concerned, different criminologists have classified them into different groups. For example, Sutherland had classified offenses into three groups. One is offenses against human body, two is offense against property, three is offenses against public courtesy, public order and public justice. Had stated the following classes of crimes. One is offenses against individual, two is offenses against property, and three is offenses against public order. W. A. Bongar had put offenses under the following classes: economic offenses, sexual offenses, political offenses, and miscellaneous offenses. Lammert had stated the following classes of crimes: circumstantial offense, two is planned offense, and three is offense of breach of trust. There were two types of offenses under English law in the beginning: offenses under common law and offenses under statutory law, constitutional law. Later on, this classification has turned into the following offenses: agitation, one is agitation, two is serious offenses, and three is misdemeanor. This classification is made according to 4 Feature Acts 1870. In fact, the above classification has included all types of offences, but no classification has been made of offences in India. Classification of offences in India: there are many criminal acts in India, therefore offences are of various types. The classification of normal offences has been made in Indian Penal Code, while for specific offences, special or specific acts have been enacted. For example, Food Adulteration Act, Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act 1989, Arms Act and Cyber Offences under Information Technology Act. Then the offences are of two types. One is offences of normal nature and offences of serious nature. The offences of normal nature are those: one is in which the police cannot arrest without warrant. They are non-cognizable offences. Two is in which the maximum punishment can be imposed up to 2 years of imprisonment. They are known as summon cases. Three in which it is the right of convict to get released on bail. They are called bailable offences. The following offences have been treated as offences of serious nature. One is in which the police can arrest without warrant. These offences are cognizable offences. Two is in which death punishment, life imprisonment can be given for more than 2 years. They are known as warrant cases, in which no claim can be made to be released on bail as a mass as a matter of right. They are known as non-bailable offences. From the above analysis, the above classification of offences has been made on the basis of nature and procedure. The procedure has been described under Code of Criminal Procedure and nature has been described under Indian Penal Code. Non-cognizable offences are those offences in which the police officer cannot arrest a person without warrant, whereas cognizable offences are those offences in which the police can arrest a person without warrant. Of Prakash versus Union of India, AR 2012 SC 545. Classification of offences under Indian Penal Code. Under Indian Penal Code 1860, the offences have been classified under the following rules: criminal conspiracy, Chapter 5A, offences against the state, Chapter 6, offences related to Army, Navy, and Air Force, Chapter 7, offences against public peace, Chapter 8, offences by public servants or related with them, Chapter 9, offence against election, Chapter 9A, offences related to disobedience of lawful order of public servants, Chapter 10, false evidence and offences against public justice, Chapter 11, offences related to coin and government stamps, Chapter 12, offences related to weights and measures, Chapter 13, offences affecting public health, peace, facilities, courtesy, and good conduct, Chapter 14, offences related to religion, Chapter 15, offences affecting human body, Chapter 16, offences against property, Chapter 17, offences related to documents and identification of property, Chapter 18, offences related to criminal breach of service contract, Chapter 19, offences related to marriage, Chapter 20, offences relating to cruelty by husband or his relatives, Chapter 28, offences related to defamation, Chapter 21, offences relating to criminal torture, insult, and humiliation, Chapter 22, attempt to commit offense, Chapter 23. This is the detailed classification of offense. Broadly, offenses cannot be divided into three groups. One is offenses against individual, offenses against property, and offenses against the state. Offenses against individual. They are also known as offenses against human body. The following offenses have been included in offenses against human body. One is simple and serious injury, two is criminal man, slaughter, murder, attempt to murder, three is attempt to suicide, excitement for suicide, four is dowry death, five is cheating, six is wrongful restraint, seven is wrongful confinement, eight is kidnapping, nine is abduction, ten is kidnapping or abducting for money or wealth. 11 is use of criminal force and attack. 12 is rape. 13 is unnatural intercourse. 14 is assault. 15 is bigamy. 6 is cruelty with wife. 17 is defamation. 18 is use of criminal force, insult and humiliation, etc. The offense of dowry death. The offense of dowry death has been added later on. The man is affected because of these offences. Therefore, they are known as offences against human body, offences against property. The offenses against property mean such offenses which affect property. The following have been included under offenses against property. One is theft, two is looting, three is dacoity, four is mischief, five is criminal misappropriation, six is criminal breach of trust, seven is cheating, eight is fraud, nine is extortion, seven is forgery, and 11 is criminal trespass, etc. Along with these, the offense of cheating by personation can also be committed. For example, if a person of low caste telling and identifying themselves as if they belong to higher caste and get married with girl of upper caste. Zivida versus LHV Prasad AIR 2000 SC 2474. Offenses against the state. Offenses against means those offenses which affect the state. By such offenses the unity, integrity and sovereignty of the country is put in danger. The following are included in these offenses: waging war against government of India, two is conspiracy to commit offense of waging a war, three is to compel the president or governor to do anything and to interfere in their powers. Four is sedition, five is to wage war against powers friendly to India and to commit robbery or looting in their territory. Six is to assist the political prisoner deliberately in running away from the country, exciting, protecting, and giving shelter, etc. Shouting slogans: Pakistan Jindabad, Azad Kashmir Jindabad in Jammu and Kashmir by receiving money from the foreign sources is like sedition. Mulchan versus State 1991, Criminal Law Report 552 SC. Similarly, residing of any foreign national in India without passport to wander with convict and recovery of arms and ammunition from his possession are offences of such types. Lal Singh versus State of Gujarat, AR 2001 SC 746. Cyber offences. This is a new type of offense which is related with computer, electronic equipment, and internet, etc. For protecting from such crime. Information Technology Act 2000 has been enacted. Tomorrow we will go through discuss the main causes of juvenile delinquency in India. What do you understand by juvenile delinquency? What measures would you suggest to reform juvenile delinquency? What are the basic factors responsible for juvenile delinquency? We will write a critical essay on juvenile delinquency in India tomorrow. Penology and victimology. Let's define the term punishment. What are its characteristics? What is the difference between law of punishment and ethics and also morality? The more popular, famous and popular the word punishment is, the more difficult its definition is. It is difficult to capture the word punishment in any given definition. According to the form in which this word is prevalent in the general public, it is not easy to have its dictionary meaning. Nevertheless, jurists and jurists have tried to define it from time to time. It is said by Westermark, punishment is limited to such suffering as it is inflicted upon the offender in a definite way by or in the name of the society of which he is a member. According to Professor Sethna, punishment is some sort of social censor and not necessity involving infliction of physical pain. According to Enric Ferry, punishment is a legal deterrent. According to Walter Reckless, punishment is a means of social control. A group seeks redress for a wrong and injury or for a violation of law and custom. Society or person in authority conceives of punishment as a device to hold persons in time, to maintain status to induce conformity. Giving the definition of punishment, Sutherland says that two things are necessary for punishment. One is punishment is given by the society or community in its capacity to person who is a member of that society or community, and two is punishment involves suffering or suffering which is considered justified according to social value. Sir Walter Moberly, adopting the definition given by Grotius of punishment, has considered the following things necessary for punishment. One is whatever is represented or given as punishment is bad and hurtful. Punishment is given for acts which are not recognized by the state. Punishment and action are related to each other. Punishment is given for voluntary acts done by a person. Punishment is given to the offender or to the person who has committed the criminal act on behalf of the offender. The following elements of punishment become clear from the study of the above definition of punishment. Punishment is an agony, tribulation, or torture. It hurts. It is given to a person who is guilty of any wrongdoing, thought, or crime. It is given by society, community, king, or state. Punishment is directly related to that for which it is given. Punishment was given voluntarily, for example, for intentional acts. This is the concept of punishment in the mind of the common man as well. It cannot be denied that punishment is a torment. This pain or torture is to be suffered by such a person who commits any crime or wrong. Its main purpose is not only to prevent crimes as well as to create fear among the society and accused persons so that no person can be inclined towards crime. In its characteristics, now let us consider the features of punishment and penal law. It is undeniable and well known that crime is a disease, a social evil. It is dangerous for the society. It is because of crimes that the entire social and national life gets disturbed. Punishment and punishment method, diagnose and disease. It is code of rules related to human conduct. If it is the reason that some features of punishment and punishment are clearly visible, such as polit- politicism, politeness, is an essential feature of penal law. The politics behind the penal law is the evidence of effective violation of the rules promulgated by the state is considered a crime. The rules promulgated by the state are related to human conduct. Speciality, specificity, is another feature of penal law. This distinction is due to the ago, conflict and antagonism between the criminal law and the civil law. Civil law is a simple law, whereas criminal law gives a firm definition of any specific act of human conduct, and in case of any doubt in its meaning, the court decides in favor of the accused. Uniformity. The third characteristic of penal law is uniformity or regularity. Criminal law is committed to provide equal justice to every person without any discrimination. In this, there is no discrimination between person to person. The quantum and nature of punishment does not depend on the social status of the person but on his criminal act. Penal penalty. Punitive penalty is the fourth feature of penal law. The main purpose of penal penalty is to punish the people who violate the laws by the state. Due to punishment, fear prevails in the society, and due to fear, people do not turn towards crime. If there is no fear of punishment in the individual and society, then the possibility of spreading anarchy becomes strong. Fear of punishment is necessary even for following the laws. Two specific principles of punishment. The following two specific principles have been propounded in the Indian Constitution and other laws regarding the applicability of punishment. Double jeopardy safety principle. An important protection has been provided to the accused under Article 22A of the Constitution of India. According to this protection, no accused can be prosecuted or punished for the same offense more than once. This is called the principle of double jeopardy protection. This principle is based on the formula of the Anglo method that nemo debate providium causa vis vexer. This principle is also in line with the principle of natural justice. A similar arrangement has been made in the US Constitution. According to the Constitution, no person can be put in the danger again for the same offense. It can also be said that no person shall be subject for the same offense to be twice but in put in jeopardy of limb. A similar arrangement has been made in section 300 of the Code of Criminal Procedure 1973. A person who has once been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall, while such conviction or acquittal remain in force, not be liable to be tried again for the same offence, nor on the same facts for any other offence for which a different charge from the one made against him might have been made under subsection 1 of the section 221, or for which he might have been convicted under subsection 2 thereof. The case of Kalavati versus State of Madhya Pradesh CIR 1953 C 131 has an important case on this subject. In this case, three things have been said necessary for the applicability of this principle enunciated in Article 22 of Constitution. The person must be an accused. The prosecution has been brought before any court or tribunal and is of a judicial nature. Has been convicted of an offence punishable under the law of prosecution. It may be mentioned here that the provision of Article 22 of the Constitution shall not apply in cases where a second prosecution is being conducted for another offence. Article 22 barred the prosecution for the same offense and not the prosecution for another offense. In the case of Makbul Hassan versus State of Bombay, IR 1953 and SC 325, the accused was prosecuted under the Sikh Customs Act and convicted and punished. He was later prosecuted for the offence committed under the Indian Penal Code. It was determined by the Supreme Court that the second prosecution was not bailed as it was tried for another offence which was different from the first. Thus, it is an important principle protecting the accused from the double punishment for the same offence. Principle of protection from statutory rigor. It is a well-established principle of criminal law that no person should be punished for any such act unless that act is an offense punishable by any law. This theory is based on the formula that null poena sine lege. This principle can also be taken as no one's behavior comes within the scope of an offense unless it is defined as an offense under any law and declared to be punishable. This theory is valid and practical as well. If an act is not declared a punishable offense, then it is not justified to punish any person for that. If this principle is not there, then there will always be a fear in the mind of every person that not knowing when which act should be declared a crime. The principle can also be seen that no act can be declared to be punishable with retrospective effect. This is that is if the fact which is not an offense on the date of its committing, then by making a law it cannot be made an offense punishable with retrospective effect. Last but not the least, I would like to thank all my brothers and sisters, ladies and gentlemen, students, scholar, teacher, trainer, professor, professional, listener, learner, officer, official. I thank all respected doctors and directors. I thank all honorable ministerial managers. I thank all honorable advocates, advisors, administrative and advisors. I thank the most honorable President Commissioner Modi. Thanks, thanks, thank you.